RIDDOR Compliance and Investigating Incidents. Introduction to the module. RIDDOR compliance isn't just a legal obligation, it's a vital component of a safe, accountable, and productive workplace. Failing to report incidents under RIDDOR can lead to hefty fines, legal troubles, and a damaged company reputation. But worse still, it could result in preventable harm to employees. This module dives into the critical process of accurately reporting and investigating incidents. You'll learn about your responsibilities, what needs to be reported, and how to handle non-compliance, all while avoiding common pitfalls that could jeopardize workplace safety and your organization's integrity. Learning objectives. By the end of this module, you should be able to understand the purpose and scope of RIDDOR regulations. Identify who is responsible for reporting incidents under RIDDOR. Recognize which injuries, diseases, and occurrences must be reported. Learn the importance of conducting internal audits and addressing non-compliance. Discover common pitfalls in RIDDOR compliance and strategies to avoid them. What is RIDDOR? RIDDOR stands for the Reporting of Injuries, Diseases and Dangerous Occurrences Regulations, 2013. This UK legislation mandates that employers, including self-employed individuals, record and report specified workplace incidents. These incidents may range from fatal accidents to minor events that had the potential to cause harm or illness. The primary purpose of RIDDOR is to ensure that relevant authorities, such as the Health and Safety Executive, HSE, or local councils, are notified of these occurrences. This reporting enables the monitoring of workplace risks and trends, supports decisions on whether further investigation is needed, and helps target sectors needing safety improvements or additional guidance. Who is responsible for reporting? Under the Reporting of Injuries, Diseases and Dangerous Occurrences regulations, RIDDOR, only responsible persons, including employers, the self-employed and those in control of work premises, are legally required to submit reports. Below is a detailed breakdown of reporting responsibilities. Employers. Employers are required to report incidents involving their employees regardless of location. This includes work-related deaths. Any fatality that occurs in the workplace or while an employee is engaged in work-related activities. Specified injuries. Examples include fractures, amputations, or serious burns. Work-related diseases. Conditions diagnosed by a doctor as being directly related to the work environment, such as repetitive strain injuries or occupational asthma. Dangerous occurrences. Near-miss incidents that could have resulted in severe harm. Premises controllers. Those who control a workplace must report incidents that occur on their premises, even if they do not directly employ the affected individuals. This includes work-related deaths and injuries involving members of the public or self-employed individuals on the premises. Dangerous occurrences, near-miss events, such as structural collapses or equipment failures that pose significant risks. Self-employed individuals. Self-employed individuals have different obligations depending on where they work. At another person's premises, the person controlling the premises is responsible for reporting incidents. Self-employed workers must ensure the responsible person is informed. At their own or domestic premises, self-employed individuals must report incidents themselves if they suffer a specified injury, an over 7-day injury, or are diagnosed with a work-related disease. Employment agencies. The responsibility for reporting agency worker incidents depends on the employment arrangement. If the agency is the legal employer, it is responsible for reporting injuries, illnesses, and dangerous occurrences involving its workers. If agency workers are self-employed, the host business is responsible for reporting incidents that occur on their premises. Self-employed individuals must report accidents occurring on their own premises or any work-related ill health conditions. Agencies should ensure that reporting responsibilities are clearly assigned based on the specific employment arrangement and communicate these obligations effectively to both host businesses and workers. Gas suppliers and engineers. Gas suppliers must report incidents involving deaths, unconsciousness, or hospitalizations linked to the gas they distribute, fill, import, or supply. This includes exposure to unburnt gas, combustion products, for example, carbon monoxide, or fire explosion events. These reports are typically handled by gas emergency service providers, ESPs, on behalf of suppliers. Gas engineers registered with the Gas Safe Register must report dangerous gas fittings, such as appliances, flues, or ventilation systems that could lead to gas leaks, incomplete combustion, or inadequate removal of combustion products, resulting in serious harm. Fittings dangerous due to lack of maintenance are not reportable. Special cases. For specific industries, the responsible person is defined as follows. Mines. The mine manager is responsible for reporting incidents. Quarries. The operator is responsible for reporting accidents and dangerous occurrences. Pipelines. The pipeline operator must report incidents involving the pipeline. Wells. For all wells, excluding water wells, the appointed supervisor or licensee under the Petroleum Act 1998 is responsible. Offshore installations. Duty holders, as defined under the Offshore Installations and Pipeline Works Management and Administration Regulations 1995, must report most incidents. For diving projects, the diving contractor holds responsibility. Employees and the public. Employees and members of the public are not responsible for submitting reports under RIDDOR. Their role is to notify the appropriate responsible persons when an incident occurs. Employees who sustain a work-related injury or are diagnosed with a work-related disease must inform their employer promptly. If employees suspect their employer hasn't fulfilled RIDDOR reporting duties, they should verify if the report was submitted. If concerns persist, they can seek assistance from a trade union or representative. Members of the public should notify the premises responsible person if they witness or are involved in an incident. What must be reported under RIDDOR? Under RIDDOR regulations, any work-related accident resulting in a reportable injury must be documented and reported. To determine if an incident qualifies as work-related, the following factors must be considered: the specific task or work being performed at the time of the incident, the machinery or equipment used during the incident, the condition of the workplace environment at the time. In addition to work-related accidents, RIDDOR requires the reporting of occupational diseases, dangerous occurrences, and gas-related incidents. Certain incidents, such as suicides, injuries related to armed forces duties, supervised medical procedures, and road traffic accidents, are exempt from RIDDOR reporting requirements. Types of reportable injuries. The death of an employee due to a work-related incident must always be reported. Non-fatal injuries that qualify as reportable include the amputation of a limb or digit, fractures, excluding fingers and toes, any loss or reduction in the quality of vision, crush injuries resulting in damage to internal organs, severe burns that cover more than 10% of the body or harm a major organ, scalping injuries caused by hair or skin becoming trapped, loss of consciousness due to head injuries or breathing difficulties, any physical or temperature-related condition requiring hospitalization. Reporting work-related diseases. Some employees may suffer from occupational diseases, conditions caused or worsened by their work environment or tasks. These diseases can be as debilitating as serious injuries and require careful monitoring. Employers may need to arrange medical surveillance for affected employees. Examples of reportable occupational diseases include severe cramping in the arm or leg, hand-arm vibration syndrome, carpal tunnel syndrome, environmentally induced dermatitis, tendinitis or tenosynovitis, occupational cancers, asthma or other respiratory disorders, any disease proven to result from occupational exposure to hazardous substances. Recording requirements. Employers must maintain detailed records of all reportable incidents to comply with RIDDOR. These records must include the date the incident was reported to RIDDOR, the date, time, and location of the incident, personal details of all individuals involved in the incident, a full description of the injury, illness, or dangerous occurrence. Employers with more than 10 employees are legally required to document these incidents in an accident book, which may also be stored in digital or physical files for convenience. These records must be kept for at least 3 years, although the Health and Safety Executive, HSE, advises retaining them for 5 to 6 years in case of legal action. Reports must be submitted to RIDDOR within 10 calendar days of the incident. Responding to and addressing non-compliance. When non-compliance with RIDDOR or health and safety regulations is identified, it is crucial for organisations to take immediate action to correct the situation and prevent further issues. This involves both internal monitoring and external interactions with regulatory bodies. Internal audits and self-checks. Regular internal audits and self-checks are crucial for identifying non-compliance. They ensure accurate reporting of incidents, up-to-date workplace safety, and proper employee training. Audits also uncover procedural gaps and ensure documentation such as incident reports is maintained. By conducting thorough assessments, businesses can ensure RIDDOR compliance, address issues proactively, and avoid penalties or legal complications. Handling regulatory inspections and queries. If a regulatory body like the Health and Safety Executive, HSE, conducts an inspection or raises queries about non-compliance, it's crucial to respond with transparency and cooperation. Ensure all relevant documents, including incident records, risk assessments, and safety protocols, are accessible for review. Be ready to explain any discrepancies and show the corrective actions taken. A proactive, positive approach to inspections helps mitigate penalties and demonstrates the organisation's commitment to maintaining a safe and compliant workplace, fostering better relationships with regulators. Common pitfalls and how to avoid them. RIDDOR reporting is a vital part of maintaining workplace safety, but there are common pitfalls that organisations may encounter. Being aware of these and taking proactive steps to avoid them is essential for compliance and safety. Failing to report all relevant incidents. One common mistake is not reporting all incidents that are required under RIDDOR. This can include over 7-day injuries, work-related diseases, and dangerous occurrences. To avoid it, ensure that employees are trained to recognise all reportable incidents and that procedures for reporting are clear. Regularly review incident logs to confirm that nothing has been overlooked. Delayed reporting. Delaying the submission of RIDDOR reports can lead to non-compliance and penalties. All incidents should be reported as soon as possible, especially fatalities or major injuries. To avoid it, establish a system that flags incidents requiring immediate reporting. Ensure that responsible persons are aware of reporting deadlines to avoid delays. Inaccurate or incomplete information. Providing inaccurate or incomplete information in a RIDDOR report can lead to confusion and investigations by authorities. To avoid it, ensure all relevant details, such as the type of injury, cause, and individuals involved, are recorded accurately. Verify the information before submitting it and cross-check with other documentation where possible. Not recording near misses. Near-miss incidents, which could potentially have resulted in injury or harm, are often overlooked. Failing to record these can prevent businesses from identifying risks. To avoid it, encourage a culture where near misses are reported and reviewed. Document all such incidents to help prevent future accidents and improve safety measures. Confusing legal requirements. Many organisations struggle with understanding which incidents are reportable under RIDDOR, especially when it comes to work-related diseases or dangerous occurrences. To avoid it, familiarise yourself with RIDDOR regulations and seek legal or expert advice if unsure. Regularly update safety protocols to reflect any changes in reporting requirements. Highlights from the module. RIDDOR stands for the Reporting of Injuries, Diseases and Dangerous Occurrences Regulations. Under RIDDOR, only responsible persons, including employers, the self-employed and those in control of work premises, are legally required to submit reports. Under RIDDOR regulations, any work-related accident resulting in a reportable injury must be documented and reported. Employers must maintain detailed records of all reportable incidents to comply with RIDDOR. When RIDDOR, or health and safety non-compliance, is identified, organisations must act immediately to correct it and prevent future issues. Thank you. You have successfully made it to the end of this module.